Hello and welcome to Legally Speaking with me, Tarun Nangia. Today we discuss a much hotly debated subject in India today called the Prevention of Money Laundering Act. Under this law, many people have been prosecuted. They include politicians, they include businessmen and people from various walks of life. And these kind of cases involve a lot of high profile people having businesses. But on the other side, there are many unknown businessmen who are doing their business. They also get embroiled in these kind of cases due to various reasons. But we have to understand what the PMLA is it different from proceeds of crime, and so on and so forth. And we go into the other aspects of PMLA, including attachment, possession. We have someone who does cases with a lot of promoters and businessmen on PMLA on a day-to-day basis. I am talking about Advocate Abhimanyu Bhandari, and he's been kind enough to give time to us today to discuss this subject. Good to see you, Abhimanyu, and thank you for your time.
Thanks for having me on your show.
So, at the outset, could you explain what is the Prevention of Money Laundering Act A, and B, is it different from proceeds of crime? And if you can explain that also.
Yes, very important question, Tarun. Tarun, we have an act called the Prevention of Money Laundering Act. So the first question arises is that when I use the term money laundering, what do I mean by this term money laundering? What is money laundering? Now, is money laundering different from proceeds of crime? Now look, typically what we mean by money laundering is that let's say someone goes and robs a bank and runs away with gold from that bank, from a locker. That person then sells that gold in the market and then buys a car with that gold. So what he's in essence doing is he is trying to launder that money. He's trying to hide that money into some other asset. Or he's trying to, let's say, sell the gold. A more complicated example would be where he sells the gold, the money that comes, he gives it to someone who he says, look, you get into a service contract with me where you show that I'm coming to your house daily to clean your house and you're paying me money for that. And that way I will integrate that money into the economy. I will show it as my bona fide income by cleaning your house, I earned this money. But actually, this money is nothing, but the source is the gold that I stole from the bank. So that is what is typically money laundering. Now, your question is very important. The problem we are facing here is, and the reason there is a lot of chaos in this area of law, is because we are not being able to differentiate jurisprudentially also between what is money laundering and what is proceeds of crime. And that is a very moot question, Tarun. If you look at the select parliamentary standing committee which debated this money laundering act before it was passed as a legislation first time round, it cautioned and warned that you have to maintain a difference between what is money laundering and proceeds of crime. Mere proceeds of crime can't be money laundering. So the person who's stolen gold from a bank, of course, has to go to jail because he has committed a robbery or he's committed a theft. But if he uses that money to buy a car, the person who sold him the car can't really get eloped into the offense. There has to be something what is called projecting that stolen money as untainted property. So the person who you're going to accuse of money laundering should actually, with the intention to hide that money, do acts and take steps to project it as legal money, money which is not tainted. Now, this is a very important distinction, a very fine distinction, but a very important distinction. And here is where I think the blurring of the line is. There is a very interesting decision of Delhi High Court called Mahanivesh. There the court, I think, reasoned, the single judge reasoned, and of course that's been pending in the division bench right now, I think. But there the single judge reasoned, I think that's a very important decision, that money laundering completes when the person integrates that money into the economy and he tries to project it as untainted money.
Can you explain this a bit in detail?
Yeah, this is very important. You see, if I take money from a bank, I rob money from a bank, or let's say I've taken a loan from a bank for the purpose of running a business, but I actually don't put it in my business. I go and use that money for some other trades. Then I take that money, no intention to put it in my business, but to make it my own money. So what I do, I give it to someone else, show it as a bona fide transaction, but it's actually a sham transaction.
Okay.
He issues me an invoice. I pay him the money, but he's actually giving me no services.
Right.
He's taken the money. Now he's showing, oh, I got this money for consideration, means because I offered him, he offered me some services. So he actually deserves that money, but actually he did nothing. So that is what is called transferring money, siphoning of money and layering it. He gives it to someone else for another transaction. But these are all sham transactions. So by the end, the money reaches somewhere, it turns around and comes back to me through a series of sham transactions. So that is what is called projecting it as untainted property at every level. Now, if this is happening, it is money laundering. But proceeds of crime can't be treated as money laundering.
What is proceeds of crime?
Proceeds of crime.
Two-line answer.
Two-line answer is proceeds of crime is the money that you have got from the crime.
Okay.
So that money you've got, of course, under the law, there are a lot of provisions in which that money can be attached. It doesn't have to be Prevention of Money Laundering Act. But money laundering is when someone actually launders that money. So, for example, if I go, taking that example of mine, if I go to the car dealer and use that gold to buy the car dealer does not know the origins of the money.
Okay.
So he's selling me a car. Are you getting my point? And he's taking the money for that. Now, it is going to be unfair if you're going to attach that money that the car dealer has taken for selling me the car.
Because he doesn't know.
He doesn't know. So, it is very important that when we look at the act, we try and differentiate between what is proceeds of crime and money laundering. Now, there is a problem, Tarun. This argument did not find merit with the Supreme Court in the 3-judge decision of Vijay Madan Lal.
Vijay Madan Lal Chaudhary. There, this was argued quite extensively. But the court felt that no, mere possession of proceeds of crime is enough. Mere possession of
proceeds of crime is enough. Then there is no difference, Tarun, between what is money laundering and what is possessing proceeds of crime. See, please note that the act is Prevention of Money Laundering Act. The act is not Prevention of Proceeds of Crime Act.
Right.
So, now if you are going to say that the person who possesses and uses proceeds of crime is also liable under Money Laundering Act, then the problem is that, and it's a continuing offense, then there is a very big issue, Tarun. The issue is that let's say the crime was committed in 1980, when there was no Prevention of Money Laundering Act.
Okay.
Let's say someone robbed a bank in 1980. That money he gave to his son then gave it to his grandson gave it to his great-grandson. That money is still in the system. They bought a property which is family property being used. Can you now say that, oh, because money laundering is a continuing offense and because you're continuing to enjoy proceeds of crime, I can now prosecute you 30 years later for money laundering?
But has that happened?
That is happening. That's a very big moot question where people are saying that the act came in 2005. The offense which generated that money happened before 2005 when there was no Prevention of Money Laundering Act. So now merely because someone is in possession of that money, you can't rope him in later.
So it's retrospective
application? Retrospective application of a penal statute.
Okay.
Now the problem is that mere possession and use of proceeds of crime will tantamount to money laundering, and that will create a big problem. So look at it in a more lighter way, Tarun. If today we look at East India Company, they plundered India. So today you can prosecute them for money laundering because they're still in possession of those. It's all the wealth is in some other country. So it's never ending then. And therefore we have to differentiate between proceeds of crime and money laundering. Parliamentary committee did that. They said that possession, use, layering, whatever, but it has to be with the intention to project it as untainted money.
Only then.
Someone who's actively participating to hide the origins of that money.
One thing that I want to know from you specifically is, this is played out in the media, the newspapers, social media, that, oh, this person has got arrested in money laundering case, he will not get bail, or the bail will come after a lot of time. I think in the past few years, except for one high profile builder, nobody else has got bail quickly in a PMLA case, with the exception when the arrest was held as wrongful. So could you simplify this for us?
Yes. Tarun, one of the bigger problems in the PMLA Act is that there are these draconian twin conditions in section 45 of the Act, which say that if you're arrested, then the court has to have reasonable grounds to believe that you have not committed the offense.
The court should have the ground. The court should have.
No, the court has reasonable grounds to believe. There are reasonable grounds to believe that the person who's been arrested has not committed the offense.
At what stage?
At the stage of bail.
So when the person is produced for bail,
yes,
when the application is filed, then itself the judge should.
Then itself. or the judge can't release the person on bail, and that is a big problem. Now, please remember that Supreme Court, in a very celebrated judgment called Nikesh Tarachand, judgment of Justice Honorable Justice Rohinton Nariman, said that this twin condition is unconstitutional, and said you cannot apply this twin conditions. And there were various reasons. One was a more technical reason. I'm not going to get into it. But the other larger reason was because it felt that a lot of water is flown through in our bail jurisprudence and in our constitutional liberties scheme of things. And therefore, now such rigorous conditions can't find a place in the statute book. Tarun, one of the biggest advocates for saying that such conditions should not be there in any act, what is called these rigorous twin conditions, was Arun Jaitley, late Arun Jaitley himself. I don't know if you're aware, but in 2012, the government at that time, the Congress government at that time, wanted to bring in a legislation where they wanted to add the same grounds for bail in a Customs Act.
The Customs Act.
They said that there the magistrate or the judge should be satisfied that the person has not committed the offence, just like the way we have it now.
Okay.
One of the persons who led the protest against this in the parliament and very vehemently opposed it was Shri Arun Jaitley, who said you can't, there is no place for such pieces of legislation in our statute book anymore. Rather, if you look at his speech and if you look at the comments he made at that time, he said that if you're going to bring in such draconian provisions, it's going to affect business morale. People are not going to come. They're going to be fearful of getting arrested. Because then for any little minor thing, you can arrest them and he has to satisfy a court that he has not committed the offence before getting a bail. And fortunately, the finance minister then, late Shri Pranab Mukherjee, our honourable former prime minister, he heard his advice and he said, I've heard, and I saw his speech, and he said, I've heard and I've considered what the opposition members have to say, and we are amending it. We are not going through with this twin conditions in the Customs Act. So that is a very important thing that happened.
So there was a debate in Parliament, and then
there was a debate in Parliament, and I think Shri Arun Jaitley ji's view prevailed, and good sense prevailed over the government of that day, which was the Congress government, and they realized that what Shri Arun Jaitley ji is saying is correct, and the finance minister withdrew that amendment to bring in that particular draconian clause. Now, this clause which Nikesh Tarachand said was unconstitutional, in Vijay Madan Lal, then they amended the act and they brought back this provision, and there was a technical reason that they had to sort out, which I'm not going into, and they sorted that out and they brought that provision back, and the Supreme Court held that now because they brought it back, Nikesh Tarachand is no more relevant and the twin conditions will apply with its full vigor. Now here is the problem. How can a judge or any court of law on day 1 or day 2, when you move your bail application, be satisfied that you've not committed the offence? That's quite a high threshold to reach, Tarun. And therefore people are languishing in jail and are finding it difficult to get bail. That's one. Second, the conditions for arresting someone are also very high in PMLA. Under section 19, before an officer arrests, he has to have material in his possession and he has to record reasons in writing that material is good enough for me to believe that the person is guilty of the offence of money laundering
before
arresting. So that's a very high threshold. The unfortunate part is that I haven't seen much jurisprudence or any judgments where court has struck down that arrest is an illegal, saying on that ground that you did not have enough material or that material was not sufficient. So your reasoning to arrest him was arbitrary.
One thing,
because the threshold under the act is very high.
Sorry to hold you, but one thing I want to know, for example, without having sufficient reasons to believe, if a businessman or anybody else is arrested, later he is acquitted, does the officer in question is also penalized? That
Tarun, no, it is, I don't know of any case where any officer has been penalized. But Tarun, once a businessman is arrested,
yes,
banks stop giving him funding. He is treated like a pariah. No one wants to deal with him. No one even wants to buy or sell with him, worried that their properties might get attached.
Oh, so he becomes a persona non grata overnight.
Correct, overnight. With a mere ECIR. I have a lot of clients in big industries where banks are now asking question, oh, we've come to know from press reports that there's an ECIR pending against you.
Even that is...
So we will not fund you. We will ask you these 20 questions.
I want to ask you one question because you shared this with us. Does this place a lot of responsibility on the ED officer or the person who's writing the ECIR that he should be thinking at least 100 times before
yes.
Because one businessman, as you say, has maybe 1,000 employees, their families,
Their
bank
families.
loans.
Yes, yes.
So it's not like arresting one single person employing 2 people, that
Yes.
only 3 people will get affected.
Yes.
A big businessman may employ 20,000 people,
Yes.
5,000 people.
Yes. So exactly, Tarun, and therefore we need a system in our country where we should have an independent prosecution agency.
Independent process.
Yeah. So basically, according to me, there should be an independent prosecution agency in such cases where there are such draconian provisions, where there's so much discretion vested with the enforcement agency. So to bring in the necessary checks and balances in any civilized nation, we need to move towards an independent prosecution agency. However, that doesn't temper the severity of my argument that it is high time we get rid of these twin conditions, whether it is in any act, whether it is in any act,
So the twin test.
the twin test, especially in economic offences. We don't need that twin test because that causes a lot of deterrence in the larger economy.
One small follow-up question I want to ask you. Instead of one single officer deciding on the ECR, can there be a committee in the enforcement directorate? So, for example, a committee of you, me and somebody else, we discuss and decide whether this case merits an ECR by the ED. It happens in income tax. Of course, it's not like a one-man decide. There is a committee which decides if you have to go for a raid or something like that. Do you think that will temper down the kind of rampant cases that are being filed?
Yes, may not, because when a lot of discretion is vested on the executive, then you need to bring in checks and balances, and probably what you said is may be a check and balance to fetter their powers.
Like when
and
3
to ensure-
officers decide, there are 3
then
different
there are
minds.
Yes. So therefore, I think that would be a very important step going forward, and therefore that what you said has the trappings of an independent prosecution agency to be put in place, which should do that. But Tarun, I think Nikesh Tara Chand was a judgment which brought in a lot of hope, and the passing away of Nikesh Tara Chand judgment, I think, is a big setback. And according to me, we should remind ourselves of what Arun Jaitley said in 2012 when the Congress tried to bring in that provision. And this section 45 should be removed from the statute book as soon as possible.
Should be removed
from the statute book. I think it has no place in an economic offence, especially when that economic offence is 7 years. Tarun, in many European countries, money laundering is a compoundable offence. Now look at the problem here. Let's say you have stolen 1 lakh rupees from someone. If you're arrested, within 3-4 days, you will get bail. 1 lakh rupees, petty theft. But if an ED officer arrests you because you took that 1 lakh rupees and bought an iPhone for yourself, then you may not get bail
for 7 years.
For next 3-4 years. 2-3 years till you've completed half of the sentence. Because the justification that is being given now, so what if there are twin conditions? You have the protection of the CRPC which says that if you've completed half of the term, then you will get bail.
But half term is 3.5 years.
3.5 years. And a lot of people are languishing in jail. So therefore, even if it is an offence where you get, and the other thing is, why is there money laundering in the first place? Because there is an offence.
Yes.
So if a person gets bail in the scheduled offence, there is no reason why he should not get bail in the money laundering offence. There's just no reason. It makes no sense. Or let's say he's on bail in the scheduled offence. There's no reason to arrest him. So these are factors which the court should take into consideration. And I think what we need is that we need a affirmative from a larger bench of Supreme Court to relook at this whole thing, hopefully one day, and give proper guiding principles to courts on how to decide such bail applications and how to temper the severity of these twin conditions.
One thing is a follow-up question which is always being discussed these days. In the newspapers, we see report property worth 100 crore attached, which was I think yesterday. Property worth 1,000 crore, property worth 4,000 crore attached. So attachments happen rampantly under the Prevention of Money Laundering Act. Is there a procedure for the same? Second, I want to know about attachment, that a property is attached at the bought value or the market value. For example, the difference may be 100 times in some cases, that you buy something at 20 lakh rupees, now it's worth 20 crores. So how the quantum is decided?
So Tarun, another quite a worrying aspect of this whole act is the way attachments are done.
Okay.
Now, assume a person has committed an offence and he's being charged for an offence. If you attach all his assets, you are literally ensuring that you break his financial spine.
Because he can't sell anything.
He can't sell anything. He can't raise money. Now, you see, I'm not talking in cases of political cases. I'm talking more from a business perspective. if you say that a businessman got a coal block allocation wrongly,
Okay.
let's say you make an allegation against him that he got a coal block from the government of India, he should not have got that coal block. He got it because of corrupt means or whatever your allegation is. That's an allegation. And then money laundering comes in, and then you start calculating how much coal came out and how much coal from that was sold in the market. And then on that you start making attachments.
There is no
Then
end.
the whole company will collapse. There is no end. Because even if he got the coal block wrongly by, let's say, indulging in corrupt means, let's assume that for a minute, any one. But the coal that he mined, he paid taxes on it, he paid royalty on it. That was done in accordance with environmental clearances.
Yes.
That coal was then captively used for a power plant to generate power or give it to a power industry so that power could be generated, so that India did not have to import coal from abroad, and therefore our consumers and the people of this country got coal at power at a cheaper price. So suddenly saying that person should also be liable for this entire thing and attach. So this is the problem that we can face. When you look at when you go by the black letter of the law, which is there in the statute book. The other problem with this attachment, Tarun, is that let's say I go and rob a bank and I buy a car. So directly the money that came from the bank went into the car, you attach the car, fine. But what if I give that money, let's say, to someone else, and I bought a piece of property from him, or let's say I give it to my sister, some part of that money as a gift, or I mixed that money with someone else's money and we bought a property together.
Joint.
The problem here is that there is a term in the act called value thereof. Means if you can't find the money, you attach equivalent value of money.
Attach the money.
So let's say you try to trace, you can't find that car, or you see that money's got mixed up with a lot of other money and into some other property. So you can't find that money. So then you see what other assets that person has.
Okay.
When you're trying to find that, you go back and see, oh, but 5 years back he gave a gift to his sister, so let's attach that property of his sister and let's rope his sister into the offense.
But that sister has got nothing to
do with it. Now there are a lot of such cases where value thereof is being
But do
abused.
courts vacate the attachment in those cases?
We saw that there was a trend when the courts were vacating the attachments. I think that has come down. I think there are a lot of attachments which are just languishing and creating a lot of problems.
Bankrupt?
Where people may go bankrupt, yes.
Because if you can't use your property, then you go bankrupt.
Rather, Tarun, I want to tell you this, that before what happened, that there is a provision in the Act that after attachment is confirmed by the adjudicating authority, ED can even come and take over the asset and dispossess you from your own house.
What do they do with it?
No question. Very good question. No clue. Now tell me, if they dispossess you from the house and you eventually win your case 10 years down the line.
Dispossessing or vacating, you have to vacate the house.
So let's say they make you vacate your house, because there's a provision under Section 8 which says that once attachment order is confirmed by adjudicating authority, they can forthwith take possession. Now, if they take possession and you eventually 10 years later win your case, you've been dispossessed for 10-15 years from your own property. Who's going to compensate you for that? Fortunately, in Vijay Madan Lal, I raised this issue in court, and I'm happy to tell you that Supreme Court, all 3 judges unanimously held that only in exceptional circumstances they can take over. In the interim, they can't take over. So that's a big relief that Vijay Madan Lal has given. But still in the statute book, there is that provision, and I think that needs to be amended. But regardless of all this, Tarun, there are issues where this value thereof term has to be defined. In value thereof, because it's not defined now, in value thereof, you can't say, oh, I can't find the asset, so I'll attach any value. And when you're trying to look for that value, you start looking at his old assets, which he has given at that time, at some point in his life, when he was doing probably an honorable trade, or when he gave it. And who it has gone to, that person gets roped in.
For no fault of
that person. So tell me, if today I'm dealing with a big businessman, or anyone is dealing with a big businessman, and that big businessman comes to your shop and says, oh, I like this watch that is there in the shop, and picks up that watch, and you give him a discount. You don't know whether that's proceeds of crime or that's not proceeds of crime. He's a good businessman, he's a big businessman, he's doing business. Why wouldn't you deal with him? Or let's say he comes and buys a property. So you can't then trace that about many years later. And that is where the problem is coming when you start applying value thereof. So that's a big problem area which needs to be. What I think we need to do is we need to attach those assets with third parties where it's a sham transaction.
Only then.
Then. So, for example, I have stolen 100 crores. Let's say someone has stolen 100 crores from a bank and he says, oh my God, I need to hide this money. So, he goes to a person and he says, look, you do something. You take this 100 crores from me and you show that you've sold me a property worth 100 crores. But actually that property is just 10 crores. And that 90 crores you keep for me. In that case, it's money laundering. Classic example of money laundering. It's a sham transaction.
But that is not in most cases.
That's not in most cases. It's a sham transaction. Go ahead behind that transaction. Attach the property. Prosecute that person who participated in this sham transaction. But when there is no sham transaction, where genuine transaction, let's say he made 100 crores a year back, and out of which 10 crores he gave it away or he did something at that time out of bona fide reasons. You can't go behind that money with a third party. So I think the test on value thereof should be if there was a sham transaction with a third party or not.
Only and only then.
Only and only then. And that would mirror the law with the UK. Because in UK also, a bona fide purchaser for consideration or a person who with bona fide belief took the benefit of that property cannot be roped into money laundering.
One final comment I need, and then we'll take the final most question, is on possession of assets. You spoke briefly on that now in your last answer. Do you think possession of assets in companies can be a problem? When I take possession of shares, then I can, I can vote on your behalf because then I get those powers because I have your shares and I will vote. Do you think that's a worry?
And that's a huge worry because if you attach the shares or you confiscate the shares and you have voting rights to run the shares. So not only are you controlling the company, you're controlling the lives of thousands of employees of that company.
So which means that's a very dangerous territory.
That's a very dangerous territory to go into. And according to me, these attachments should not happen in the ordinary course. I think that we need to change the entire system of attachments. Unless there's a conviction, there should not be an attachment. At least there should not be an attachment till there is a charge sheet and charges have been framed by a court of law.
Okay.
So there was a provision in the Act which said that only in exceptional circumstances, till a charge sheet is not filed, can you resort to making such attachments. But I think that is just gone on the wayside, and there are a large number of attachments which are happening even when charge sheet has not been filed.
Yes.
So I think rather the law should change and they should say that till there is no order on charge in the predicate offence, there should not be an attachment.
Okay.
Yeah. In the UK, in the Proceeds of Crime Act, there, attachment and confiscation only happens after the person is convicted under the scheduled offence.
After conviction?
After conviction. Because, for example, just take it like this. What if everybody in 2G case got acquitted?
Yes.
Tarun?
Yes. All of them. Yes.
All of them got acquitted. And if you've attached their assets and the shares of their company and all the huge amounts that were involved, all those companies would collapse.
Yes.
And 6 years is too late. By the time you get an acquittal order, the whole thing is over. The other thing is that if you start attaching assets, let's say of a builder, of anybody, he's not able to go and settle with customers.
So third party gets impacted.
Yes.
Which is
that's another thing. I think in real estate industry, where large number of home buyers and customers are buying and selling flats, you cannot go in and attach assets of a builder, because if you do that, that has huge policy considerations, because you are inhibiting that builder from settling with customers. See, there are legacy issues that some builders have who've not been able to complete projects because of various reasons. I'm not saying they're right or wrong. Let's not take I'm not on the moral call. Right? I'm saying if you want that company to come back and settle with those customers, you can't make wanton attachments, because if you do, you're clipping their wings.
That's a very fair point.
But so this whole attachment area has to be relooked at.
Let's see.
Having said that, Tarun, there are a number of good judgments. I think Delhi High Court, in a landmark judgment called Himachal Emta versus ED, quashed an attachment order.
Okay. They've quashed.
Subsequently, in Prakash Industries, the Delhi High Court noted Himachal Emta, and on that basis quashed another attachment order.
Okay.
And came to the rescue of certain businesses.
So there have been cases.
There have been cases, and these are of course matters which will eventually, I think, will go up to Supreme Court one day. But I'm saying that we have seen that there is a growing jurisprudence where courts are quashing attachment orders where it's wanton. Lastly, but not least, that I know that a lot of people have said that Vijay Madan Lal needs to be relooked. But let me tell you, there are also certain very hidden gems in Vijay Madan Lal, and there are certain very good aspects. For example, before, people were being prosecuted even after the scheduled offence was over. Yes. Or a person was acquitted. Vijay Madan Lal came down very heavy on that. And I think after that, there are a number of orders passed by High Court and Supreme Court where if a person has got acquitted in the scheduled offence, he doesn't have to face the music under the Prevention of Money Laundering Act. Of course, because if there's no crime, there is no proceeds of crime.
There's no proceeds of crime. Thank you for explaining and taking us through various details of the Prevention of Money Laundering Act. We will request for your time again when the Supreme Court hears the review on the Vijay Madan Lal Chaudhary judgment. I think a lot of people have filed for review, and I think Supreme Court will hear club petitions. I think it happens from this August, if I'm not wrong, and that's the time we get to discuss this again. But I'd like to thank you for
Thank you.
making us understand about arrest, position, attachment, and the issue of bail in PMLA. Also, specifically, the issue where you discuss the problems arising out of attachment and the problems arising out of the twin test or the twin condition. That remains a worry for most promoters and businessmen who, in a sense, as you explained, are employing people and bank loans have to be paid. We thank you for your time, and it was a good discussion. So, guests, this was our interesting episode on the Prevention of Money Laundering Act, and Advocate Abhimanyu Bhandari, who does these cases day in and day out, shared details of what things need a relook and what are the implications of attachment, position, twin conditions for bail, and all of that. On our next show, we'll come up with some other topic, but thank you so much for joining us. Thank you so much.
Thank you.